In 1944, a book by the Polish Jewish lawyer Raphael Lemkin was published in the United States. It was titled Axis Rule in Occupied Europe. It was a dense legal study of Nazi laws, decrees, and methods of governing conquered countries. Hundreds of pages filled with documents, definitions, regulations, and evidence. But among those pages appeared a word that had never existed before: genocide. Lemkin combined the Greek word genos, meaning family, tribe, or people, with the Latin suffix sidi, meaning killing. But he did not merely invent a convenient term for mass death. He was trying to force the world to recognize that the destruction of a people was not a side effect of war, not ordinary brutality, not an accidental massacre, and not simply a large number of individual murders. It was a separate crime. A crime against the very existence of a human group. Lemkin understood something terrifying. The mass destruction of a people could be an obvious moral crime, but as long as it had no precise legal name, governments could pretend they did not know how to punish it.
If a crime has no name, it is easier to hide. It can be dissolved into wartime statistics, called the internal affair of a sovereign state, explained as the result of extraordinary circumstances, protected behind the principle of sovereignty, dismissed with the claim that international law is powerless. This is not only the story of how one word was created, it is the story of a Jewish lawyer who saw the abyss between human conscience and legal language and devoted his life to building a bridge across it. Before we continue, support this episode with a like and subscribe to the channel. This is where the names of people whose work changed the world are brought back into the light, even though they themselves were often left in isolation, poverty, or obscurity. Raphael Lemkin is usually remembered with a single sentence: the man who invented the word genocide. It sounds almost like a dictionary entry. But if the story ends there, the most important part disappears. Lemkin was not sitting quietly in an office, searching for an elegant word to describe a tragedy that had already ended. He was creating a legal weapon against a crime that had existed for centuries, yet had too often remained without a precise definition in international law. Peoples had been destroyed before him. Communities had been deported. Languages had been banned. Places of worship had been demolished. Children had been torn away from their families. Educated people, religious leaders, writers, and teachers had been killed first so that a group would lose its memory and its ability to speak in its own name. Entire communities could be scattered and deprived of their land, faith, culture, and future. Yet international law had long been built primarily around states. It protected borders, treaties, property, diplomatic relations, the right of one government not to interfere in the affairs of another. The law could still recognize an individual as the victim of murder or violence, but an entire people, understood as a single collective, remained almost invisible.
Lemkin saw that the problem was not only that people were being killed. Sometimes the very possibility of a people continuing to exist was being killed. That distinction became the heart of his entire life's work. Raphael Lemkin was born in 1900 into a Jewish family living on a small farm near Volkovysk, a town that was then part of the Russian Empire and is now located in Belarus. It was an Eastern Europe of constantly shifting borders, languages, and governments. Jews, Poles, Belarusians, Russians, and other peoples lived side by side. A national border could move faster than a person could change the documents in his pocket. And a Jewish family in this region understood very well the difference between formal citizenship and genuine safety. From childhood, Lemkin was interested in the history of persecution based on religion and nationality. He knew about anti-Semitic pogroms that transformed Jewish streets, homes, and shops into landscapes of fear. He later studied law in Lviv and began building a legal career in Poland.
He was interested not only in how to punish a person for a specific murder, he asked a far more difficult question. What should the law do when a crime is organized by the machinery of the state and when victims are selected not because of anything they have done, but because they belong to a particular group? The fate of the Armenians of the Ottoman Empire made an especially powerful impression on the young Lemkin. During the First World War, Armenians were subjected to mass deportation and destruction. Many of those who organized these crimes escaped meaningful international punishment. In 1921, a trial took place in Berlin. Sogomon Tehlirian, an Armenian, was accused of shooting Talat Pasha, a former Ottoman minister and one of the principal organizers of the persecution of the Armenians. Lemkin was struck by the contradiction. The law could put a man on trial for killing one former minister, but where was the court capable of judging the destruction of an enormous human group? Lemkin, of course, did not defend personal revenge as a substitute for justice. On the contrary, he saw the case as evidence of a dangerous vacuum. When international law does not exist, revenge takes the place of a courtroom. Despair takes the place of evidence. One man with a weapon takes the place of an institution. But why did the killing of one person have a precise name and a legal procedure, while the destruction of an entire people remained almost nameless? Lemkin began asking this question long before the Holocaust, and that is critically important. His path is sometimes retold too simply. The Nazis destroyed the Jews of Europe. Lemkin lost his family, and afterward he invented the word genocide. But the documents reveal a more complicated story. He had been searching for a legal definition of the destruction of groups during the interwar years. The Holocaust did not create his interest from nothing. The Holocaust transformed a long-standing legal question into a personal wound. In 1933, Lemkin prepared proposals for an international conference on the unification of criminal law in Madrid. He described two crimes. The first he called barbarity, acts of destruction committed against people specifically because they belonged to a national, religious, or racial group. The second he called vandalism, the destruction of art, books, monuments, and cultural treasures through which the life of that group was expressed. His idea was remarkably modern. Lemkin understood that the destruction of a people does not always begin with mass shootings. Sometimes it begins with the closing of schools, the banning of a language, the removal of books from libraries, the destruction of religious buildings, the dismissal of teachers, the removal of a community's leaders, the rewriting of history, the transformation of its culture into supposed proof of its inferiority. Only afterward does physical destruction begin. Lemkin's proposals were not adopted in Madrid. The Polish authorities did not even allow him to attend the conference in person, fearing that his speech would be interpreted as anti-German propaganda. That same year, Adolf Hitler had already become the head of the German government. Many people still regarded his threats as political rhetoric. Lemkin approached them as a lawyer, trained to read not only words, but also the intentions concealed behind those words. This was the first step in his argument. The crime existed, but the appropriate law did not. The next step was even more terrifying. The world watched as the warning became state policy. On the 1st of September 1939, Nazi Germany invaded Poland. Lemkin fled Warsaw. His path to safety led through a devastated country and across northern Europe. Eventually, he reached Sweden, and later received an opportunity to travel to the United States. In 1941, he began teaching at Duke University. He had survived. But survival, in his case, did not bring peace. Europe remained under the rule of the Nazi occupation system. His parents, relatives, acquaintances, and the entire world of his childhood were still trapped in a place where human life had been divided into categories, and Jewish ancestry had become a death sentence. Lemkin began collecting Nazi laws and decrees arriving from occupied countries. It was a very particular kind of work. These were not eyewitness accounts recorded after the war, not photographs of liberated camps, not confessions from defendants. They were documents created by the occupiers themselves while the crime was still being carried out. Orders confiscating property, changes to civil law, restrictions on education, forced population transfers, the dismantling of local institutions, bans on language and culture, the economic destruction of some groups, and the transfer of their property to others. Lemkin assembled these documents into a single system and realized that Nazi domination could not be described by the word occupation alone. This was not merely the seizure of territory. It was an attempt to alter the human composition of Europe itself. Some peoples were meant to be destroyed. Others were to be weakened, divided, or reduced to a powerless labor force. Still others were to be stripped of their culture and their capacity for independent existence.
The most radical part of this system was the total destruction of the Jews. It was then that Lemkin fully formulated his new concept. In Axis Rule in Occupied Europe, he explained that genocide did not necessarily mean the immediate killing of every member of a people. It could be a coordinated plan of actions aimed at destroying the essential foundations of a group's life, with the ultimate purpose of eliminating it as an independent human entity. Lemkin described political, social, cultural, economic, biological, physical, religious, and moral methods of destruction. His original understanding was broader than the legal definition that would later appear in the Genocide Convention. He saw a group as a living organism. It has families, language, education, religion, memory, culture, an economic foundation, social bonds. If these elements are systematically destroyed, a people can be eliminated, even when some of its individual members remain physically alive. The central point was this: people were being persecuted not as separate individuals, but as members of a group. That was what distinguished genocide from ordinary murder. The word became a weapon. Not a weapon of revenge, a weapon of precision. Before the term existed, one could say that mass killings had taken place. There had been atrocities. There had been a brutal occupation. There had been discrimination. There had been deportations. Each of these expressions described one part of what was happening, but none of them revealed the unified objective: to destroy a group as a group. The new word connected actions that had previously seemed separate: the killing of people, the destruction of families, the theft of children's futures, the destruction of religion, the confiscation of property, the suppression of culture, deportation. It transformed all of them into elements of a single criminal design. Sometimes a new word does more than describe reality. It changes how the world is obligated to respond to it. But while Lemkin was working on the language of law, the destruction of European Jewry continued. According to the United States Holocaust Memorial Museum, while he was in Nuremberg, Lemkin learned that 49 members of his family, including his parents, had died in camps, killing centers, the Warsaw Ghetto, and death marches. The number is easy to pronounce: 49. But in family memory, it is not a number. It is voices, rooms, holiday tables, children's faces, elderly relatives, private jokes, arguments, letters. People who knew a man before he became a famous lawyer. People for whom he was not Raphael Lemkin from a textbook, but a son, a brother, a nephew, a cousin. For Lemkin, genocide was not an academic concept. It was a word filled with the emptiness left behind by his own family. But he did not transform his family's loss into a demand for a special law protecting Jews alone. That was one of the profound moral qualities of his work. The Holocaust was for him both a personal Jewish catastrophe and evidence of a universal danger. He wanted to create a law that would protect Armenians, Jews, and other peoples. National, ethnic, racial, and religious groups, large and small, powerful and nearly defenseless. Those with their own state and those without an army, diplomatic representation, or the ability to speak from an international platform. Lemkin understood that a powerful state can defend itself with weapons. A small or scattered human group needs the protection of law. The Second World War ended. Nazi Germany was defeated. The International Military Tribunal began its work in Nuremberg. For the first time, the world saw the leaders of a powerful state placed on trial for international crimes. The tribunal considered crimes against peace, war crimes, and crimes against humanity. The word genocide was used in the indictment to describe the deliberate and systematic destruction of racial and national groups. Lemkin succeeded in bringing the term into the Nuremberg proceedings, but genocide had not yet become a separate crime, carrying its own independent judgment. The word itself did not appear in the tribunal's final judgment. Moreover, the legal framework for crimes against humanity at Nuremberg remained connected to aggressive war. This created a dangerous problem. What if a state destroyed part of its own population during peacetime? What if the crime was not connected to an invasion of another country? What if no border had been crossed, yet an entire people disappeared within it? Could this be treated as an exclusively internal matter? For Lemkin, the answer was obvious. No. Sovereignty could not mean that a government had the right to destroy the people under its authority without punishment. Punishing Nazi leaders was necessary, but the punishment of individual criminals was not enough for him. He wanted international law to recognize the very logic of destroying a people as criminal. We can now say it more precisely. Raphael Lemkin did not merely invent the word genocide. He forced international law to see what history had shown for centuries. Sometimes it is not only individuals who are killed. Sometimes there is an attempt to kill a people as a people. We have reached the halfway point of this story. Tell us in the comments whether you had heard the name Raphael Lemkin before, or whether you knew only the word he created. And support the video with a like and a subscription. It helps us tell the stories of people whose ideas became part of the modern world, even while their own names remained in the shadows. After Nuremberg, a new struggle began for Lemkin. Its battlefield was no longer occupied cities or the halls of a criminal tribunal. It was the corridors of the United Nations, reception rooms, hotel rooms, diplomats' offices, letters, telephone calls, brief conversations between meetings. Lemkin had no state of his own prepared to place its full diplomatic machinery behind his idea. He was not a government minister. He did not lead an international organization. He did not control a major foundation. He could not promise governments loans, military alliances, or trade agreements. What he had were documents, legal arguments, and an almost painful determination. He explained to representatives of different countries why genocide could not be treated as a form of ordinary murder. Murder is directed against the life of a particular person. Genocide is directed against the existence of a group. An individual becomes a victim because that person represents the group and forms part of its future. Lemkin searched for states willing to support a resolution. Representatives of Cuba, Panama, and India played an important role. They brought the issue before the first session of the United Nations General Assembly. On the 11th of December 1946, the General Assembly adopted a resolution recognizing genocide as a crime under international law. It was not yet a complete convention. The resolution did not settle every question, but it destroyed the central excuse, the claim that the destruction of a group belonged exclusively to the internal affairs of a state. The United Nations was instructed to prepare an international treaty. Lemkin became one of 3 experts involved in drafting the initial text, alongside the jurists Vespasian Peller and Henri Dondieu de Vabre. Yet even after recognition of the basic principle, the most difficult work was only beginning. A precise definition had to be negotiated. Which groups should be protected? Which actions should count as genocide? Should the destruction of culture be included? Should political groups be covered by the convention? Who would prosecute the accused? Could the crime be punished if it was committed during peacetime? Every word carried consequences. Every comma could broaden or narrow the future law. The diplomats represented states, each with its own history of violence, deportation, colonial rule, or repression of minorities. Many supported the moral principle but feared the creation of a legal instrument that might one day be used against their own governments. The final definition was therefore the result of compromise. It was narrower than Lemkin's original concept. Cultural genocide was not included as a separate category in the final text. Political groups were also excluded from the protected categories. But the central principle survived. The destruction of a group would become an international crime in both war and peace. On the 9th of December 1948, the United Nations General Assembly adopted the Convention on the Prevention and Punishment of the Crime of Genocide. The title of the document itself was significant. Not only punishment, prevention. Lemkin did not want international law to appear only after mass graves had been opened, camps had been liberated, and the dead had been counted. The law had to act earlier, when propaganda begins, when members of a group are stripped of their rights, when state institutions transform people into a dangerous or supposedly alien category, when the infrastructure of future destruction is being constructed. Article 2 of the Convention defined genocide as acts committed with the intent to destroy, in whole or in part, a national, ethnic, racial or religious group as such. These acts include killing members of the group, causing serious bodily or mental harm, deliberately inflicting conditions of life calculated to bring about the group's physical destruction, imposing measures intended to prevent births, and forcibly transferring children from one group to another. Every word matters. Genocide is not a synonym for every mass killing. For the legal classification to apply, a special intent must be demonstrated. The intent to destroy a protected group, in whole or in part, specifically as a group. War crimes, crimes against humanity, and genocide may overlap, but they are not identical concepts. Lemkin's word became one of the gravest terms in international law precisely because its application requires proof of a particular purpose. The Convention also established the duty of states to prevent genocide and punish those responsible for it. After receiving the required number of ratifications, it entered into force in January of 1951. 2 seconds. At that moment, the personal word of one Jewish refugee became part of the language of international law. One can imagine the hall of the General Assembly. Interpreters behind glass, diplomats raising their hands, the text of the document resting on their desks. But there is no need to invent a triumphant speech for Lemkin, or turn the moment into a Hollywood scene. The fact itself is more powerful than fiction. A man who only a few years earlier had fled a devastated Poland and did not know the fate of his family, had succeeded in having the destruction of a people recognized as a separate international crime. The Convention did not fall from the sky. It did not appear automatically after the liberation of Auschwitz. Moral horror alone does not create a legal standard. Between a photograph of a crime and an article in an international treaty lie years of arguments, drafts, rejections, compromises, and votes. Behind that work stood one man with folders, letters, and determination. Lemkin transformed personal loss into a bureaucratic, diplomatic, and moral siege of the world. He approached representatives of governments, reminded them of the issue, placed documents in their hands, searched for support, explained it again, argued again, returned again after being rejected. There is none of the spectacular heroism of a war film in this. No attack, no shouted command, no liberated city.
But sometimes history changes in precisely this way. One man refuses to leave the corridor until the officials agree to at least read his document. And yet the victory was not complete. Lemkin wanted a broader understanding of genocide, one that included the systematic destruction of the cultural, social, and economic foundations of a people's life. The independent concept of cultural genocide was removed from the final text of the convention. One especially important element remained: the forcible transfer of children from one group to another. That provision reveals how deeply Lemkin understood the continuation of a people. A people exists not only in those who are alive today.
It exists in the children to whom language, faith, family memory, and a sense of belonging are passed. To take those children away is to attempt to break that transmission. Even here, Lemkin's work was not merely a reaction to mass killing. It was an attempt to understand what a human group is made of and the different ways in which it can be destroyed. But there was another uncomfortable truth. The adoption of the convention did not end genocide. After 1948, humanity once again witnessed the destruction of groups and other mass atrocities. Laws do not possess armies of their own. A document cannot open the gates of a camp, stop a military column, or force a government to admit that it has adopted a criminal plan. States can deny facts, argue over definitions, block decisions, conceal documents, eliminate witnesses, use the word genocide as a political weapon, or avoid it when the evidence demands a serious investigation. Lemkin did not save the world from genocide, but he deprived the world of one excuse: the excuse of silence without a word. Before him, governments could claim that international law recognized no such crime. After him, a different question remained. Why had the existing law laughing been applied in time? That does not make Lemkin's victory a small one. On the contrary, it reveals the boundary between law and political will. He gave humanity a legal standard, but making governments act in each particular case became the responsibility of the generations that followed. After the convention was adopted, Lemkin did not stop. He campaigned for countries to sign and ratify the document and then incorporate its provisions into their national laws. He taught, wrote, and continued persuading. Many states were slow to accept the obligations. Even the United States, the country that had given him refuge, did not ratify the convention during his lifetime. For Lemkin, this was painful. He had won a word for humanity, but the application of that word depended on governments that often moved more slowly than the memory of the dead demanded. He did not become wealthy. He did not achieve widespread public fame. His name was not spoken as loudly as the names of politicians, generals, and judges. Much of the world used the concept he had created while knowing almost nothing about the man who had spent years fighting for its recognition. On the 28th of August, 1959, Raphael Lemkin died in New York. He was 59 years old. The United States Holocaust Memorial Museum describes his final years with the words, "impoverished and exhausted by his efforts." Yale University Press, which later published his unfinished autobiography, also notes that he died alone and in poverty. Victory came, but it did not come as a triumph. He did not live to see his name become a symbol of an entire field of international law. He did not see international tribunals where lawyers would debate genocidal intent. He did not see research centers, university courses, and memorials where the word genocide would be spoken alongside his name. He accomplished what mattered most and departed almost unnoticed by the wider public. There is a particular kind of loneliness in Jewish history. A person speaks about a danger before others are prepared to hear it. They tell him he is exaggerating, that the time is not right, that politics is more complicated, that governments will never agree, that existing laws are sufficient, that a new definition would create too many uncomfortable questions. And then the warning becomes reality. But even then,
Recognition does not come automatically. Lemkin lived through precisely this sequence. First, he argued for the international protection of groups and was not heard. Then, the Nazi system destroyed European Jewry and most of his family. After the war, the world acknowledged the catastrophe, but its legal language remained incomplete. And so he continued the struggle, not for revenge, for law. This is an important part of Jewish memory. Not only to mourn the dead, not only to preserve photographs and names, not only to tell children where their family came from, but to try to transform memory into an obligation imposed upon the state. Lemkin wanted the dead to be more than mourned. He wanted their destruction to be named as a crime. Behind his legal formulations stood vanished towns and communities, Jewish homes in which no one remained to light the candles, Armenian families who had lost their native towns and villages, peoples from whom others had tried to take language, children, and the right to continue existing. People whose suffering could once have been described as tragedy, cruelty, or historical inevitability, but not as a crime with precise international elements. Lemkin refused to accept that uncertainty. For him, memory could not remain only a tear. It had to become law. Today, almost everyone knows the word genocide. Journalists use it, politicians, human rights activists, historians, judges. Sometimes it is spoken too easily, as a way of emphasizing the scale of any violence. At other times, people refuse to say it because the legal and political consequences are too serious. Lemkin's legacy demands two forms of responsibility at once. The word must not be reduced to an ordinary accusation or used as a synonym for every war crime. But neither should people hide behind caution when there is evidence of an intent to destroy a protected group. Precision does not weaken the moral meaning of the term. It protects it. If every mass crime is automatically called genocide, now the term will lose its legal precision. But if people are afraid to use the word, even when its legal elements are present, the law will lose its ability to fulfill its purpose. Every modern debate about genocide is also a debate about evidence, intent, the limits of law, and the duty to prevent. And behind every such debate stands, almost invisibly, a Jewish lawyer from Eastern Europe who once decided that the old language was no longer enough. What, then, should be remembered from this story? First, Lemkin did not begin thinking about the destruction of groups only after the Holocaust. Long before the Second World War, he had been influenced by the destruction of the Armenians, anti-Semitic pogroms, and the absence of an international mechanism of accountability. In 1933, he proposed the concepts of barbarity and vandalism in international law, linking the physical persecution of people with the destruction of their culture. In 1944, he introduced the word genocide in his book about the Nazi occupation system. At Nuremberg, the term appeared in the indictment, but it had not yet become an independent crime in the final judgment. And finally, on the 9th of December 1948, the Genocide Convention transformed Lemkin's idea into an international legal norm, although its final definition was narrower than his original vision. These are 5 facts, but together they form a single staircase of evidence. First, a man recognizes a crime for which no precise legal name exists. Then he understands that without a name, it is almost impossible to create a law. He creates the word. He loses his family in the crime that the word describes. He transforms personal pain into an international campaign. He wins a convention. And he dies without receiving, during his lifetime, the gratitude that his work deserved. 3. Raphael Lemkin could not bring his family back. He could not undo the Holocaust. He could not resurrect the destroyed towns, homes, names, and generations. He could not return Armenian families to the homes they had lost. He could not ensure that states would always honor their own promises. But he did what a lawyer who had survived an age of catastrophe could do. He gave the world a word. And then he forced the world to recognize that behind that word stood a crime. Genocide. Not merely killing, not merely war, not merely cruelty, but an attempt to destroy a people as a people. And that is why Lemkin's story is not only a story of international law. It is the story of Jewish memory, refusing to remain only an act of mourning. It became law.